Thanks everyone again also for your patience. We are catching up with time from the very beginning. It is again a learning by doing process with this hybrid format. So thank you for your patience. And thanks to everybody who has participated in the workshop sessions. I will just give the word without further ado to Carole Billier and to Luca Veysen, and then to all the workshop chairs for the closing session of this conference. So Carole, the floor is yours.
Thank you, Matteo. Dear participants in this room and online, we are just moving up now to the very last part of this conference, a plenary session once again, the closing panel discussion regarding the way forward before all. And I have the pleasure to share this with Luc, whom I have been working with for so many years. I can even take a session on the moor with him. And well, the word will be to the workshop chairs, Annalisa Savarese, Sarah Mead, Haro van Asselt, who should be present here, Marianne Peters, and Jaap Spier present online. Look, should we simply follow the order as it is given on the program? So if we could move to Annalisa Savarese, present online, and hear her summing up of ideas and key messages from the session she chaired, this would be wonderful.
Thank you very much, Carole. Thank you very much, everyone. It was a very rich session I had the pleasure to chair this morning. The panel was on human rights and climate litigation, and it brought together 5 papers on rather diverse set of matters whose common denominator was that to deal with the role of human rights in climate litigation in Europe. So we started with Konrad Lachmeier from Sigmund Freud University in Vienna, who considered the constitutional context of climate litigation using a case study approach and compares decisions of the Austrian and German constitutional courts in landmark climate cases. Konrad reflected on the role of constitutional rights and constitutional courts in the climate emergency, and personally I exhorted him to bring this line of inquiry further, as I believe there is a clear knowledge gap here and that we all need to better understand the practice in this area and the specific role of constitutional rights and constitutional law in climate litigation. Then we had a paper by Surya Pratin Roy and Alexandra Gochu from Trinity College Dublin. They considered another important milestone in European climate litigation. This is the People versus Arctic Oil. Now, as people probably know already, this is a famous case where the Norwegian courts were asked to consider the lawfulness of new oil licenses in the North Sea. It was a complex case where human rights and climate change law were unsuccessfully used to argue against new licenses. There is a lot to unpack concerning this judgment, including the role of the right to a healthy environment, specifically in climate litigation, and its justiciability. So a very welcome contribution to the literature. And again, I exhorted the authors to go further and really contextualize this case vis-a-vis other human rights-based litigation happening in Europe. Then we had a paper by Giada Giacomini from La Sapienza University in Rome. Giada considered the potential for human rights-based climate litigation brought by indigenous peoples in Europe. There has hardly been any such litigation yet. So Giada's paper is a normative paper contrasting the approach taken by the Inter-American Court of Human Rights in environmental cases brought by indigenous peoples with that of the European Court of Human Rights. I'm sure people in the room know already that the Inter-American Court has been way more progressive than the European Court, and Giada suggests greater cross-fertilization between the case law of the two, and that the European Court of Human Rights take heed from the progressive case law of the Inter-American one on environmental matters. So I suggested to Giada to really use this opportunity to inform future climate litigation that surely will come brought by indigenous peoples in Europe, given that lack of practice in this area, and to develop her paper further in this direction. Then we had Gillian Sprenger from Cambridge University. She considered climate migration and Europe's duty to act in this connection on a human rights basis. This is an area, again, where there is a lot of scholarship, but very little judicial practice, especially in Europe. This is, of course, puzzling, as there is an enormous need to fill in the gaps in the law concerning climate migrants and the unfolding tragedy of climate impacts all over the world. So more case law on this is certainly coming, and some of these cases are being brought outside of Europe. So I suggested also to Julian to really look carefully and closely to inform the recommendations in the normative paper to the European case law on non-refoulement, because there is an area, this is an area where there is a lot of case law, again, that could usefully inform future litigation brought by climate migrants in Europe. The last paper was a paper by Nele Schut from Ghent University, and Nele considered specifically the translation hurdles associated with scientific evidence in climate cases before international human rights courts. This is a complex question, but does not only concern climate cases indeed, but more broadly concerns the use of scientific evidence by international judicial bodies. So Nele tries to speak to that literature and really consider specifically the practice that exists in this area, again, in the European context, and how it might apply in the context of climate litigation. So if you like, another normative paper, given that there is hardly any litigation, but an important paper that could inform the thinking of the European Court of Human Rights as it considers the climate cases that have been brought before it. So to wrap up, as I said from the outset, this is a rather diverse set of papers, as you may gather from my summary. These papers well illustrate the many different facets of the relationship between climate change and human rights law, and the way the two intersect specifically in the context of climate litigation. As I'm sure people in the room know already, there is an ever-increasing number of rights-based climate cases all over the world, and especially in Europe, where so far the most of these cases have taken place. So there is a desperate need to see the big picture and the story behind the single case. And I myself have modestly contributed to this work, and there is a special issue of a Journal of Human Rights and Environment that we try and connect the dots between these different climate cases that are based on human rights. And why did we do that? Because human rights-based cases have their specificities, and the most successful European cases so far in terms of victories obtained in court, like Urgenda, Milieu Defense, in Neubauer, all rely on human rights in different ways. In fact, very different ways. What I'd say, though, is that, of course, not all human rights cases are successful. And I'm sure that those listening to Judge Heike yesterday will have a feeling that we should not be that hopeful about the cases that presently are before the European Court of Human Rights. That might well be the case, and history will tell what happens here. But what I would say is that we must remember these are just the first cases to land before the court. There will be many more. And I would also add that there is great potential for future human rights-based climate litigation in Europe, because we have such rich history of environmental jurisprudence before human rights bodies and courts in our continent. And if you ask me, as I already foreshadowed in some questions I asked yesterday, the greatest potential is possibly in the area of enforcement of climate targets. We have not seen any litigation of this kind yet based on human rights, but I'm sure that we will see more, because this is consistent with the practice of environmental cases brought before human rights courts in our region. So this is where the big contribution of future case law lies. And I think that the papers that were presented in the workshop I chaired this morning were very useful to inform this future litigation and the strategies of applicants and the thinking of courts. And I think I'll leave it to that. And thank you very much for listening. Thank you.
I think I was the chair of the second session. So shall I just go straight into it? Yeah. Okay, so I had the pleasure of chairing the second workshop, which was on state responsibility and climate change litigation. We had 5 presentations, so we had a lot to get through, but it was a very stimulating conversation, discussion, both online and for those in the room. And we also had quite a range of papers. So we really went from, we covered many different topics within that sort of broad area of state responsibility and climate change litigation. So the thread I think that connected them all was a desire to explore the opportunities and the challenges associated with using climate litigation as a tool for enhancing the mitigation ambition of states. So we were really exploring those challenges against states, but also the sort of social and constitutional challenges that arise when that, which is associated with that type of litigation. We were very lucky because we had the benefit of having Carol in our room. So we had also the benefit of her perspective. And I think that really added to a rich discussion. So our first speaker was Carlotta Garofalo. She addressed the topics, both her and actually our next speaker, who was Janis Krusman, both kind of explored that topic of fair share and how much states should be doing, or what their sort of their part in addressing this gap in emissions reductions, how that should be distributed. So Carlotta explored, she did a wonderful job covering, exploring what is actually a very complex and complicated topic. She looked, however, that even when a country's mitigation policies are defined by best available science, there are many value-laden considerations that go into that. So there are normative questions, not just scientific questions associated with the topic of fair share, and she covered those. And then she looked at how how the courts in Urgenda, Neubauer, and Klimatzak had dealt with some of those ethical questions. And she found on that basis that there was something of a gap, that human rights standards were not really presenting were not allowing courts to adopt an approach which was really ethical and in light of climate justice. So, and that the courts appeared to be having a bit of difficulty with closing that gap. And that was particularly evident, say, in Neubauer, where the court didn't consider that it was possible to really take into account the impact of climate change on those foreign plaintiffs, and to take that into account when it was assessing the burden for Germany. There was a really good back and forth also with Carol on this discussion, on her paper, and we reflected on this issue in the context of actually bringing climate litigation and the kind of difficult choices that litigants need to make when they're bringing these cases. What is really ethically fair, and what do we think that the court is actually going to be comfortable with ordering? And then we had Janis Krusman, who was had a very interesting paper that looked at that it should be it would be helpful, he was saying, for courts to look at also imported emissions, so that this approach by courts to only focus on the territorial emissions of countries was falling short, and he compared that also to the situation of Royal Dutch Shell. So in the case of Royal Dutch Shell, the court looked at the scope 1, 2, and 3 emissions of the company, and those scope 3 emissions were effectively looking at the carbon reduction potential of Shell. So if Shell didn't put those their fossil fuel products on the market, then that would reduce also the consumption of their product. So he was saying that that put quite a high standard onto the Shell Corporation that wasn't reflected similarly in the litigation against national governments. So he was arguing that state responsibilities should also entail imported emissions and therefore focus on the state's carbon reduction potential instead of territorial emissions. And in our discussion, we explored the difficulties associated with that, how, the difficulty of finding a legal hook for that, given that the territorial emissions are really at what is at the center of the UNFCCC regime. But he also commented that even just to start this discussion in judicial dialogue, to have it flagged as important in judicial decisions would be a helpful first step. Marijn van der Sloot, it was really helpful to have a constitutional perspective. He was he wanted to explore with us, with the other participants, what is climate litigation and how does it fit into the sort of theoretical division, whether we could really how we could explain what the courts had done, basically. So he argued that a comprehensive account of the relevance of climate change for constitutional law was missing, and that currently climate change and mitigation measures are mainly seen in constitutional law from the perspective of human rights. And he wanted to show that climate change has broader ramifications for constitutional law and that this approach is too narrow. He also touched on the impact of the European Green Deal and the possibility of introducing something like a socio-economic council to deal with the issue of climate change to account for its sort of constitutional significance. I see we have Jaap here presenting next, so he might have some reflections also in this regard of the kind of constitutional law significance of the Urgenda judgment. So our two final papers, we had Alan Zakowski, who gave an account of climate litigation and its potential in Poland. He dealt with the empirically applicable law to strategic litigation in Poland and presented a theoretical framework of new social movements, climate-friendly agenda, and how that could be fit into the Polish context. It was interesting to have this sort of much more theoretical perspective on climate litigation. It's certainly not something that I have engaged with as much working in practice, but it was interesting to have that contribution to the overall discussion. And our final paper was by Suzanne Hanke, and she was connecting climate litigation with the international climate change regime. So she was looking at the Neubauer reasoning in relation to intergenerational equity, and she was reflecting on this being a possible path to refine the definition of intergenerational justice under the UN climate change regime. And she suggested that it offers a framework for future climate action that illustrates the responsibilities of the state and sets parameters for international cooperation. So I thought that was an interesting to see how climate litigation, or whether we could expect climate litigation to have an impact on the further development of the international climate change regime. And she was also reflecting on the upcoming global stocktake, which will be coming up, I believe, next year. So that is a whirlwind overview of the 5 papers that we had in our session. I think that it was great to see such deep thinking on the opportunities and challenges for climate litigation against states. I think we saw from yesterday that there is a lot of scope for further research in this area, and that especially as Europe has a particularly heavy responsibility in relation to mitigation, being a region of developed countries and also with high levels of historical responsibility, I think it makes sense for there to be a lot of scholarship in sort of inquiring into the responsibility of European states and the possibility for climate litigation to close the accountability gap. But that said, then it also raises constitutional issues, which I think were also touched on in our session and is also important to consider. Also in light of the EU. So I think I'll leave it at that because I'm already at 10 minutes. But I really enjoyed all of the presentations. It was a really stimulating discussion. And I hope that all of those conversations can continue into the future. So I will now hand over to the chair of the third workshop.
Maybe before going to the third workshop, I would like to thank both chairs of the panels for bringing us an overview of what was happening over there. And I think you gave us a flavor of the final papers who will coming out this conference. So I think there is a lot of rich material that is waiting for us. Before giving the floor to the next chair, maybe I would like to give the floor to Carol for some reflections on the first two issues.
Yes, Luc and me somehow also have to add an upper layer to this already upper layer of everything that has been discussed this morning. And the first thought we wanted to share with you is the following. It touches also on the discussions we had yesterday about what is a successful climate case, what is a climate case successful, and all the things surrounding a case and which are benefits for promoting the social narrative around the climate change we face. And this morning, we had in our session several papers really highlighting ethical and moral issues, constitutional issues as the foundations of the societies we live in, and discussions about social legitimacy and so more, and how you could draw in citizens in everything that should happen in society, thanks also by having cases decided. And in fact, where this brings me to is that all the discussion indeed about climate change law and climate change litigation cannot be isolated from so many ethical and moral and other aspects, and that this is simply the academician making the point. It's an obvious point, but then moving to the litigation position, here I'll talk like the lawyer I also am in climate change litigation, the importance of remaining a lawyer, and I hope, Mark, that you will recognize that captures everything around climate change arguments that put forward your case, also capturing just what's the spirit and the mood of society and the issues raising there, and just being like antenna and integrate it and digest it and try to put into your cases not only the arguments that you know you will get something with, but also arguments that are purely educational for the judges to start with, but for the wider society, like everybody studying those court cases. Also, in fact, a good climate change litigation lawyer should be an interpreter of realities rather than an executor of law, texts of laws and case law, well read and well understood, an interpreter of realities, and contribute to building the social narrative around climate change. And I think this is a very important point, that climate change litigation should contribute to building the social narrative around climate change action, because it is from the social narrative that is the feeding area of decisions wider in society and of acceptance wider in society. That was the first point I wanted to make. Thank you.
So thank you. So let's go to the next panel, and I'm happy to introduce to you Harro van Asselt, who is in Hasselt here on the spot. He's working at the University of Eastern Finland but I heard yesterday mainly from Utrecht these days. So please, the floor is yours.
Right, thank you, Professor de Vreesen. Right, like the other panels, also here we had a very rich and interesting discussion. So I'm happy that the organizers have been recording all of these sessions so we can look back at them. Maybe unlike Annalisa and Sarah, I'm going to do it slightly differently. So I'm not going to summarize paper by paper, but I'm rather going to try to make a few main takeaway points that I got from the session. Also in inserting and injecting some of my own views and thoughts here. But let me start with the main points. So our session was about international trade and investment protection and its relevance for climate change litigation. So my main point is that yes, the disputes and judicial proceedings in front of international economic tribunals does matter for climate change. So they also need to be taken into account in the broader discussion on climate change litigation. At the same time, they matter in different ways. And this is something important to keep in mind. So we have a first group of cases which can be considered anti-regulatory cases in the terms of Peel and Asofsky. We see that states are increasingly ramping up their climate policies. They're doing also at different speeds. So we can expect more and more of these cases coming in. And these cases, this first category of cases, we can maybe see as shield cases, as also Patrick Jeffrey was talking about in his presentation at our session. So we have governments using climate change protection as a defense in an argument, whether it's in front of the WTO or in front of an investment tribunal. And when does this happen? Well, we first see that a number of countries are increasingly implementing fossil fuel phase-out policies, which of course affect the core businesses of various fossil fuel companies, whether it's utilities or oil and gas majors. So we already have seen a number of these cases emerging. We know of the cases in the Netherlands. So we have RWE and Uniper both challenging the Dutch government over its coal phase-out. We have Rockhopper, which is challenging the Italian government. We have TransCanada in Canada challenging the US for its reversal of the Keystone XL pipeline. So we see any number of these cases coming up, and I would predict many more cases will still come in the future when fossil fuel phase-out policies are being ramped up. But then we also see a different set of policies potentially being challenged. So we have policies to protect against carbon leakage. We had a presentation on the European Union's carbon border adjustment mechanism, which is of course also a trade measure at the same time as a climate measure, which may ultimately lead to it being challenged in front of the WTO. But there's also other types of policies that are generally aimed at protecting the environment or targeting the emissions embedded in products that are traded across borders, which again may run afoul of WTO law. And then we have a number of discriminatory renewable energy support policies, which might or might not be justified by the Paris Agreement. And also here we've already seen in the past that some of these policies will indeed be challenged in the context of the WTO. We've had Canada, which had its feed-in tariff challenged by other countries. We've had India, which had its solar emission challenged by the United States, and then India retaliating against United States also for their renewable energy support measures. So again, we already see some activities here. And interestingly here, we actually, at least in the WTO context, we haven't seen many states actually using the Paris Agreement or their nationally determined contributions as a defense yet. But I would predict that the more cases we will get, the sooner we will actually see those defenses coming up. Now, another group of cases can be thought of more as sword cases, again, using the terminology that Patrick Jeffrey also used, where dispute settlement in international economic law could actually be used to strengthen climate action. And here, the most well-known cases are the cases in investment arbitration related to renewable energy, with renewable energy producers challenging host states for reversing some of their sometimes successful renewable energy policies. And here we heard from Eva Tokarewicz on the Polish anti-wind law, which basically restricted this again successful wind policies and really made it quite difficult for investors in wind farms to actually go on with their projects. So here we also see this happening in a number of countries, a lot of them in the EU. But we can also think beyond what we've seen so far. So think creatively in the context of the World Trade Organization. The World Trade Organization has a whole body of rules focusing on subsidies. Can we use that body of rules actually to start targeting fossil fuel subsidies? And some would argue, yes, maybe in some cases you can. But also, if we go back to investment law, it might be also interesting to look at whether in some cases investors might actually use the absence of countries of taking action under the Paris Agreement to challenge those host states. So I think a few presentations in our session referred to the Peter Allard versus Barbados case, where an investor actually used, I think it was the Ramsar Convention and the Convention on Biological Diversity to basically say, Barbados, you're not implementing this well, and that is actually ultimately affecting my investments. And likewise, could we think in some cases where a country is not implementing adaptation actions to also say, well, if you don't do this properly, you're not really complying with the Paris Agreement. So therefore, of course, you're affecting my investments. It's maybe a bit of a stretch of an argument, but I think it's at least something that would be worthwhile looking into. Then the second main point, and this all goes to the paper by Eva Tokarevic, which is that the possibility of dispute settlement can have a chilling effect on the introduction of climate measures. And Eva in her paper talks about the broader notion of regulatory chill. We have different types of regulatory chill, but she also introduces a new category of procedural chill, and I'll try to explain that briefly in a second. Regulatory chill is well known both in the trade context as well as in the investment context. So in the trade context, it's the idea that the existence of the WTO and trade rules might actually prevent some countries from adopting climate measures because they might be afraid that another country will bring them in front of the WTO dispute settlement body. That might be true. It's of course very difficult to figure out whether that's indeed the case. But it doesn't always hold true. And again, going to the paper by King Yubu on the European Union carbon border adjustment mechanism, very clearly a trade measure, very clearly a measure that may indeed affect other countries, which may indeed start dispute settlement under the WTO, but it so far doesn't seem to stop the EU from actually implementing that measure. But of course, ultimately, this may lead to dispute. Then in terms of the other forms of regulatory chill that Eva touched upon, it might also be because of the threat of a dispute. So maybe a country or a government might refrain from implementing certain measures because they know that an investor has already informed them, maybe informally, that if they go ahead, they will bring them in front of an investment arbitration. And then also, Eva noticed the point about cross-border chill. So it might even be the case that an investor or a country might refrain from adopting a certain climate measure because they know that their neighbor has actually already been brought in front of investment arbitration. So again, there's all kinds of ways through which investment arbitration might stymie climate measures without actually the rules being applied. But then Eva, in her presentation, also distinguished the notion of procedural chill, which I thought was a very interesting case, and I already mentioned it in Poland, where a government might ultimately refrain from adopting a measure due to the possible effects on ongoing arbitration proceedings. And here the case that she highlighted, I already mentioned, is Polish anti-wind law. And Poland is actually considering to reverse or to partially reverse some of its quite draconian anti-wind policies. But they're delaying and delaying. And the question is that because it might actually be have a negative effect on their ongoing proceedings, which then might actually might lead to bigger awards and bigger compensation to these investors that have challenged this Polish anti-wind law. Moving on to the next point. The next point is very much related to a very interesting paper by Alessandra Monti and Linnea Nordlander from Copenhagen University. And they very much focus on the linkages between human rights law, international economic law, and climate protection. And they argue that human rights law could be used to strengthen investment arbitration and to also help ultimately get better climate outcomes in a number of ways. They argue that human rights law could be used to argue for an exception under investment law. They argue that human rights law could be used to argue for counterclaims in investment arbitration. And they argue that the more procedural human rights could be used to make interventions in investment proceedings, for example, through amicus curiae briefs. The key question though, and which is also a question that I asked them, is like, well, which human rights can then be invoked and how can they be invoked? Because we know, of course, that not all countries have the same human rights system in place. Not all countries have ratified all the human rights treaties. So how can we actually make sure that this is done in a relatively consistent way? And of course, there's ways to argue, well, that at least, like the Dutch court argued in the Shell case, soft law, like the guiding principles on business and human rights, might now actually be argued to apply across the board. But again, seeing that happening in individual investment disputes might be still quite tricky. And I think that's also why they ultimately argue for including relevant provisions in the investment treaties that these claims are often based on. Just to note also, I think there might also be other linkages between human rights, international economic law, and climate change. And here I find one of the most interesting developments, the Duarte Agostinho case, which is very much focused on imports. So basically, it's a human rights argument with a view to climate protection, but the types of argument or the type of argument that is made is arguing in favor of a certain measure that will ultimately have trade effects. So I think also here there will be an interest, both academic but also practical, of these three bodies of law converging. Right, moving on to the next point, and that's that there are interactions which I think will also be very, very interesting to explore in the future between international investment arbitration as well as other forms of climate change litigation, which we've talked about in other sessions. And again, this comes from the paper by Alessandro and Linnea, and they make specifically a link between first the agenda rulings, and then following that, the coal phase-out law, which the Dutch government has adopted, although and maybe Sarah can come in here as well. I don't think there's necessarily a one-on-one connection between Urgenda and the coal phase-out law. But of course, that coal phase-out law itself was then the basis for several claims by Uniper, by RWE against the Dutch government. That's their investments were affected by that. But clearly here we can see that climate change litigation might lead governments to adopt more stringent laws, which might then ultimately lead to investors, again, basing their claims on those laws that have been adopted. And I think it's that interaction that can be explored in more detail. But also here, I think the other connection they made was that human rights litigation, and again, they made a reference to the Shell ruling more specifically, might also help to clarify the legitimate policy objectives that a country is pursuing, or it might also specify the investor obligations. So also here, I think there might be interesting interactions between climate change litigation in a, let's say, more narrow sense and investment arbitration. There's 2 points more, if I'm allowed. So the next point is one that I try to discuss also with the speakers, is that the question of whether international economic dispute settlement is actually well equipped to deal with climate change cases and climate change concerns. And here I think these questions apply at different levels. One is the applicable law. We know, of course, that the applicable law in the WTO is primarily the WTO. We know, of course, that the applicable law in investment cases is not necessarily international law or international environmental law, but it's primarily the investment treaties on which the cases are based. So, of course, there will be possibilities to bring in other international law, including human rights law and international environmental law. But in the WTO context, this is primarily limited to interpretation. So, and even if an arbitral tribunal or if a WTO dispute settlement body would actually apply or look at other law, they will still do so primarily from the lens of their own regime, what Martti Koskaniemi refers to as their structural bias. So this also then goes to maybe a more procedural point, and we learned a lot from this also from Patrick Jeffrey, is that even so from a procedural perspective, some of these institutions might not be well placed because they don't have the right expertise, or they have certain procedures which make it very difficult because, for example, under investment arbitration, it's not very transparent. So Patrick Jeffrey in his presentation highlighted a number of ways through which at least investment arbitration seems to be in the process of reform to address some of these concerns. There's discussions on the Untitled, which he mentioned, which might apply to investment arbitration more broadly, but might also help to basically make these proceedings more climate friendly. And I think these are very interesting developments to look at. But even if we look at some of these developments, and this is my final point, it may well be that some of the reforms that we're actually looking for are not necessarily reforms focused on these bodies themselves, on the dispute settlement bodies, but rather the broader bodies of law that they're based on. So the trade agreements, the investment agreements that these regimes ultimately are based on. And maybe we need to think more about, well, what kind of climate provisions are necessary in preferential trade and investment agreements? How can we make sure that these agreements will not just be about avoiding harm to the climate, but also actively try to protect some of the climate through their provisions? And I think there's a lot of creativity that is necessary here to basically give us an idea of how these provisions could look like. And then finally, and maybe the more extreme end, we could also say, well, are these treaties necessary in the first place? And we know here there's a number of NGOs and scholars as well that have been looking into, well, we just need to get rid of some of these agreements altogether, because that's the best way to actually help the climate. I'm just throwing these out here as options that I think are part of the broader discussion with relation to trade and investment protection. And I'll leave it at that. Sorry for taking a little bit long.
Thank you, Aro, for giving us more than a flavor of what was discussed in your panel, and we were looking, of course, forward to the full papers on this item. May I now invite Marianne Peters from the sister faculty of Maastricht University to update us on what was happening in the fourth panel workshop.
Indeed, thank you very much, Chair. Dear participants, this session dealt with procedural rights and climate change litigation, but I think I can translate that title with procedural hurdles to climate litigation. And I think across the 5 papers we saw in this session, there were many attempts to discuss how to overcome procedural hurdles. And we also saw some creative thinking and how to change indeed procedures in order to arrive at more efficient decision-making and more effective litigation. Because procedural rights not only relate to litigation, but they are also related to decision-making. And we had 4 papers on litigation and 1 paper on decision-making. And I will start off with the 4 papers on litigation. Indeed, I will discuss the 5 presentations in a row to pay due respect to each presenter and the interesting thoughts. And I will summarize it and try to give away the takeaways that are sometimes, most of the times, of a positive nature, to recommend further developments to overcome the hurdles. I start off with the paper from Geert van Kalster from the University of Leuven, and he delved into private international law, a field that I also read about, but I find also a complex field of law. And but it's a crucial field of law because of the wide variety of actions in many jurisdictions. And here delved into the forum shopping character of a private international law, where litigants try to find that court that is interesting for the claim, for adjudicating the claim, not only in terms of choosing that court that is creative in his words, but also in terms of costs, the cost of procedures, and very important, also the enforcement of the judicial order. And we can remember that yesterday we also touched upon, yes, what about if there is a judicial order, what about enforcement? And here pointed at that important element as to in choosing the forum. Here also delved in that into the Shell decision, first instance, also in terms of enforcement, where he pointed out Shell headquarters has moved to the United Kingdom. And the relevance of that could be that the enforcement then of the judicial order would then happen in the United Kingdom indeed. His conclusion, after having discussed many interesting elements of private international law, was actually about substantive environmental law. So with private international law, it opens up the possibility that the court applies foreign law. And he indicated that it starts to pay off all the work on improving environmental law in all kinds of jurisdictions. And he mentioned also the example of Brazil, that they are paying off when we see the adjudication, the litigation in the field of private international law. So courts applying foreign law indeed. So that was a very positive conclusion there at the end of his presentation. Then we moved to class actions and public interest litigation. And Ander Maglis from the University of Milan and Leuven again delved into the implementation of an EU law that is about class actions. And this EU law was initiated also after the Dieselgate affair, so to enable consumers to start class actions. And Ander delved into the implementation of this EU law into Italy. And something interesting has happened in Italy. It is a rather ambitious implementation, and it's a wider, a more ambitious implementation than was necessary according to EU law. So the wider implementation includes that not only consumers can use it, but also representative organizations can make use of it. And there is already one case pending. It's a dramatic environmental case, the ILVA case, which also has led to an ECHR procedure. And it's of course hard to predict the outcome, but we can already see that this new opportunity is then being used in practice, and it will be very important to follow up what will happen there. So this possibility allows for injunctive action, and that's what the claimants ask for in this case of a polluting industry, and for compensation. I think Ander concludes this is a very powerful and as such very welcome new possibility for litigation. But he also, and I think that is also what academic lawyers do, he also pointed that there is also a need for critical reflection. And that's what we know. If we introduce very powerful instruments with power, there also needs to be critical reflection. Well, where does it lead at? And I did not put that forward in the discussion, but last week, and I am not an expert on class actions, there were some concerns raised in Dutch newspapers about this new instrument in the Netherlands, about also the courts that would become over-occupied with all kinds of claims. So yeah, that's on the one hand good news because the new instrument is used, but it can also lead to real problems in the organization of the courts. Judge Luc Verheysen intervened with a question on enforcement. So we discussed that as well very briefly in the limited time. You also pointed at the recovery mechanism. And finally, we discussed against whom can these actions be established, and it is against private actors. So there's also here room for improvement, also to see whether such actions can be put forward against governments. Then we proceeded with a paper from Ronsom Salim from Ashton University, and he proceeded actually also with this, let me say, public interest litigation, starting from the agenda case from Book 3, Article 305, that enables public interest litigation. It was a my law study in 1987 when I saw that introduced in Dutch law, and it's interesting to see that it has got worldwide attention with the famous agenda case. But what Ronsom then did is to move to Poland and to Croatia to study how in those countries public interest litigation is possible or not. And he came first forward with a very nice conceptual explanation of access to justice, what it should mean. And against that benchmark, he examined the situation in Poland and in Croatia. And he also pointed at some room for improvement. Hence, he pointed at procedural hurdles, like in Poland, there the NGOs cannot bring the collective action and there are restrictions for the individuals. And in Croatia, their representative organizations can bring forward litigation, but there he raised a critical reflection. He was critical in the sense that there was a question of independence of these representative organizations. Then he also pointed out that there is a way forward. There is a legislative development at the EU level with a law that I did not yet know, that is about representation action directive. And that is something that needs to be further examined to see how this can improve indeed such hurdles as being observed. That was about public interest litigation. Now we move to the EU level, actually also with, let me say, public interest litigation, but then done by individuals. I think that was also basically the point from Ronsom Salin, who said, well, we really have to work towards possibilities for representative organizations to bring cases, because it's very hard for individuals to bring cases, also in terms of energy costs. But at the EU level, as Joska Slakke from the University of Bremen has explained to us, we have also the famous hurdle, the Kafka's hurdle of the Plowman doctrine. It's of course the famous Carvalho case and the biomass case. But what does Joska do in his paper? He provides a very interesting examination of the structural problem that is embedded in EU procedural law to bring indirect judicial review. With that, he means that there is a possibility for national courts to submit a preliminary reference to the Court of Justice of the EU, but particularly in those cases that claim for more ambitious action, he constructs that there he does not see any procedural possibility, given the criteria for submitting preliminary references, to bring such a reference to the Court of Justice of the EU. So there we are stuck. On the one hand, the Plowman formula limits standing to the Court of Justice of the EU, and the way how we, how the indirect judicial reviews regulation also, judicial review is regulated, also does not provide access to justice. And then he makes a further step, and then he starts with creative thinking, like how can this be overcome? Because I think we all feel if things cannot be brought to justice, there's a fundamental problem. And there he comes forward with creative thinking, where he says that cases in which validity questions cannot be referred to the Court of Justice, as an exception, the narrow interpretation of the individual concern should be changed. In the discussion, I added very briefly that such creative thinking could also happen for submitting preliminary references, and I think that debate has not closed yet. Finally then, and I already saw the chair indicating, but I also want to pay due respect to the only paper we had on procedural rights in decision-making. Indeed, this conference is about climate litigation, and as we already discussed also yesterday, the decision-making, the substantive decision-making at the EU level, for instance, but of course also national orders is very important. And Doreen Coppens, affiliated to Maastricht University, delved into public participation with the taxonomy regulation, where she explained on the one hand this very complex decision-making process under the taxonomy regulation and the way how the European Union, and particularly the European Commission, has followed up its obligation of effort of Article 8 of the Aarhus Convention to enable the public to participate. She comes forward with suggestions how to fill in Article 8. The current practice is that more than 45,000 comments have been provided in the public participation procedure. And we have seen that now for the delegated act under the taxonomy regulation, and now we have seen that the Commission has changed in the better regulation, soft law approach, the public participation opportunities. And Doreen delved into possibilities on how to live up to the obligation of effort to have public participation, but in an efficient way. And she pointed at the possibility to use representative organizations in order to provide input to the decision making, but also citizen jurors and perhaps a combination thereof. So all in all, I think we have seen creative thinking in this session on how to overcome procedural problems. We also have seen that substantive law is also important, of course, to be successful in procedures. And my own takeaway as well is we have discussed as well complex legislation, legislative developments yesterday in the session, also with Rode Verheyen pointing at that there is a need to delve into the legislation. But we also see with procedural law, these legislative developments on mass action, class action, representative organizations. Adding to that, there was also now a call to regulate something at EU level, what constitutes an ENGO, etc. So this was a momentum, and there's still a lot of work to do there. Thank you very much.
So thank you very much. And now let's turn to the fifth panel. And I have to present to you Mr. Jaap Spier, former Advocate General with the Supreme Court of the Netherlands, the Hoge Raad. But after his retirement, he is even more active as an academic at Cambridge University and at Stellenbosch University. And he authored also two, I think, very important publications on climate obligations for states and climate obligations for enterprises as the main author. And it seems that if there is a plan to see us live, that climate change is becoming sending storms so that trains cannot run. It was the last time we planned to meet, it was the case, and now it's the case also. Please, Jaap, you have the floor.
Many thanks, Luc, for your kind introduction. And seeing the time, I'll try to be brief. And for the remainder, I can strongly recommend you to read the impressive papers of the speakers. The presentations in our panel have in common the urgent need to explore options to overcome the deadlock in political arena. They predominantly strike an optimistic tone, pointing to successes and hopeful developments. The speakers discussed groundbreaking cases, potentially promising avenues to bring states and enterprises, including financial institutions, to their senses. The Paris Agreement can play an important role to stem the tide, as recent judgments illustrate. So can human rights and soft law, which can at least color the open norms of hard law. The speakers didn't hide, of course, the challenges. Not all courts will be courageous, and causation may be a major stumbling block. Maria Antonia Tigre discussed groundbreaking judgments urging states to reduce their greenhouse gas emissions and whether their rulings can be used to interpret the standard duty of care in litigation against the corporate world. She discussed how the successes can be ambition still is a little bit less. The agenda judgment served as a source of inspiration for many cases in Europe, Asia, Latin America, and the US. It fueled litigation against corporations, so far with one notable success, i.e. Milieudefensie versus Shell. 63 cases against enterprises are pending, 14 about emission reduction. And the Shell judgment is particularly important because the District Court of The Hague issued injunctive relief to reduce the emissions along the entire value chain of all companies belonging to the Shell Group. Maria Antonia mentioned groundbreaking pending litigation against car manufacturers. And she emphasized the cross-fertilization of courts in climate litigation, which is becoming gradually more significant. Given the global nature of climate change, a growing feature of strategic climate cases is to include plaintiffs from beyond a particular jurisdiction where the claim is filed. Hendrik Schoukens discussed an unlikely cocktail to safeguard carbon budgets and challenge unsustainable lockings. He reminded us that over the past years, we have seen a surge in the number of climate change litigation against states, with the agenda judgment as a well-known standout. Predominantly focused on impact assessment cases, emphasizes that avoiding the realization of further unsustainable lock-ins, which might render the achievement of the Paris pledges unlikely, is key to avoid a further depletion of the global carbon budget. Drawing upon the recent case law regarding the intersection between human rights, environmental impact assessments, and national planning law, Hendrik argued that climate consideration will play an ever more important role in the context of project review. Courts are reluctant concerning expansion of airports and progressive concerning new coal power plants. Recent case law struggles with new oil and gas projects. Some judgments break new ground, others leave much room to the government. Hendrik argues that the litigation strategy focusing on challenging unsustainable fossil fuel projects and beyond represents a cumbersome yet inevitable complement to the existing litigation strategies. And Maria Zamorska finally reminded us of one of the main objectives of the Paris Agreement: strengthening the global response to the threat of climate change by, I quote, making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. However, since 2015, major banks have invested almost $4 trillion in coal, oil, and gas companies. She discussed several legal bases for climate change liability of financial institutions, predominantly disclosure and the polluter pays principle. And although financial institutions are not polluters, they contribute to climate change aggravation through financing fossil fuel extraction. She mentioned two major hurdles, causation and jurisdiction, and emphasized the urgent need for more investments in renewable energy. Policy reforms, she mentioned, must encompass procedural changes such as specific nexus, proof of damage, standing, and changes concerning the merits of the financial institutions' liability regime. Thank you very much.
Thank you very much, Jaap Spier, and also the other chairs of the different panels, and of course the panelists and the presenters. So we have I think we have now more than a flavor of what papers are produced, and sometimes in some cases, like in the case of Geert van Kalsen, probably it's a book. So I give now the floor to Carol to see what will be done now with all the material we have.
Thank you so much, Luc. Yes, I think there is an announcement that matters. There will be a conference book. And we already have a publishing agreement with Intersensia. And editorial instructions will be shared shortly after this conference to go forward to also with this aspect of the whole of the conference initiative. And then there remains mainly to thank everybody on behalf of the Ivano, Alina, Matteo, and myself, to thank our guests, to thank the chairs online and present, to thank the participants online as well as on site, to thank the IT teams we did have. And we did deserve a very warm applause to start with the incredible Liam Strachan in London. We did a wonderful job managing everything and solving problems. The IT team being continued and by local Hasselt people. And I also want to mention Anja Drijboms. I do not know if she's here. I hope she will have a look at the recordings at some point. And then of course, Justine and Elisa, who have been helping a lot also to get through the problems we had this morning. Just to wrap up, a warm thank you to all who in one way or another helped to make this event happen in London, elsewhere, and here. Thank you so very much. And as a final note, after we already had a very short coffee break, I really need to attend now to stomach matters, to food. We have a lunch in the cafeteria, you know it by now. And this afternoon we will go and have a visit of the Geneva Museum in Hasselt, which is 100 meters, 200 meters away from here. And it will be easy to find for those who are on site. They only will have to go straight ahead from the door here, and it will be there. It starts at 2.
Yes.
This is the very end.
And the very last announcement is that, of course, we want to take a conference picture, right? Since after kind of 2 years almost, I think. So I think we could gather together just outside the auditorium in the main hall to take the picture, and then straight away to the lunch break, to the light lunch, and then for whoever stays over, of course, the Geneva Museum, the flavor of Hasselt, as a last touch. So once again, also from my side here, thanks to everybody who joined this conference and made it successful, I think. So it was a joint effort, and I think we discussed, I mean, we have a lot of insights that we can be built on in the future. So thanks once again to everybody who is online. Thanks Annalisa, Sarah, Jaap Spier. Thanks everyone. It has been a tremendous pleasure. So until soon.
Thank you. It was a pleasure. Ciao.
Bye.